I just said that I plan to discuss a little bit the history of the relationship between the United States and the ICC, then go over some of the recommendations which the American Society of International Law Task Force that I co-chaired with Will Taft came down with in order to start a new and more constructive route for those relationships. And finally, if we've got time, I'll take a few minutes to give you my own appraisal of what I think are some of the accomplishments and some of the obstacles that the court still faces. First, let me just tell you a little bit about the origins of this report, a copy of which all of you can get from outside. The American Society for International Law, with some foundation help, thought that this was an opportune time to look at our relationship of the United States with the court because of several developments. One, of course, as you're well aware, we have a new administration. And at least during the campaign, then candidate, now President Obama, said he was going to review, after his election, the relationship with the ICC. The second is that the ICC is itself about, in 2010, to undergo a 7-year review conference in which it will listen to and discuss proposals, some proposals, for amendment to the Basic Rome Statute, as well as take up the crime of aggression, which many parents will get into in much more detail. And third, of course, is the ICC has been on board now, since 2002. It's admittedly, in the history of courts, it's still a very young court, 7 years old, but still it does have a track record of some. I'm just going to tell you briefly who the members of the task force were, because I think you will see that purposely they represented both sides of the spectrum. In other words, they were not confirmed supporters, all confirmed supporters of the ICC. Some started out indeed as skeptics. So our membership, apart from Will Taft and myself, included retired Associate Justice O'Connor, Steve Schwabel, who stepped down several years ago as the president of the International Court of Justice, the old World Court, Mickey Edwards, who was a former Republican House member, Ruth Wedgwood, who I think has written on both sides of this issue, and certainly can't be pigeonholed on there, Mike Newton, who worked on behalf of the government in setting up or working with the ICC when it was doing its elements of crime. And I hope I haven't left somebody else off. But at any rate, I'll pick it up if I haven't. But anyway, it was, we did actually have Harold Coe with us, but only for a couple of meetings before he was nominated to become counsel on the State Department. So it was a very lively group. Now, when we started looking at the history of the relationship between the U.S. and the ICC, Don has alluded to some of it. We weren't really right, my understanding is, I was not there. We worked pretty intensely and cordially with the whole development of the ICC until it got into the very later stages. In fact, there were resolutions passed early by Congress in the early 90s, etc., saying what a good thing this was. And there was a general air of approbation. Now, the United States had a lot of concerns, some of them justifiable, and I think the drafters, the ICC, did actually accommodate some of them. They did not accommodate a few, and I'll just mention them very briefly, which still persisted at the time that the ultimate decision was made not to vote for the. One, there was a concern about independent prosecutors. Whether you would have, and this, remember, is at the stage in the late 90s when the United States has had its own experience with so-called special prosecutors. So a little bit of that aura, I think, was still there. And the notion, the fear was that there would be some wild man / woman kind of prosecutor who would, the day after the ICC came into being, or the prosecutor took over, immediately go after either the United States or Israel or some country in order to work out a vindication of political differences. So there was a great debate about how much independence, how much authority the prosecutor should have. That was one area of concern. Another area of concern was the so-called authority in the Rome Statute to have jurisdiction over a national of a non-party, if indeed that national of a non-party fell within the normal jurisdiction which you've outlined for the court. There was also, it wasn't so much articulated, but you could read between the lines, sometimes read the lines themselves, a concern that some of our people, and I think especially the opponents of the act, stressed servicemen and women, that they would suddenly be being tried in this foreign court by foreign judges, and that didn't seem. And there was some concern about whether or not the trials of the court would accommodate all of the due process requirements, even though I will say that, or note, that at the time the American Bar Association, or very soon after, endorsed the ICC as indeed having the requisite due process protections. But at any rate, it started off in the early 2000s with the United States having quite an antipathy toward the court in both its expressions. I mean, you had expressions by people in the State Department, I think primarily John Bolton, not primarily, but certainly he was there saying, we hope the court will wither and die. And not only did we express that, but we began I skipped one part, and I'll get back to it about President Clinton's signing. But by the time the Bush administration took over, we also had Congress in the early 2000s passing the American Service Members Protection Act, which I was serving abroad at the time in the ICTY in The Hague. It was familiarly known as the Invasion of the Hague Act, because what it did was really say several things. One, it said, we don't want any money, any U.S. money spent on anything to do with the ICC. We don't want any agencies, we don't want any agency to have any relationship, any U.S. agency, any relationship, or to answer any requests for help from the ICC. We don't want any territory, we don't want any investigations for international criminals who might have escaped over here to be done on U.S. territory, and on like that. Excuse me, I skipped a very small part of this, and that was that not so small part. That at the end of President Clinton's term, he did sign the act, sign the Rome Treaty, but he said very specifically, I'm not going to send this to Congress because I don't think our problems are yet solved. But by his signing it, it did allow for a couple of years in that interim for U.S. Personnel who did participate in some of the early activities after the Rome Treaty had been signed before the court was actually established, such as, I mentioned one of our task force members worked on drafting the elements of crime, which is a fundamental attachment to the Rome Treaty, because it defines these things called war crimes. Genocide, of course, is pretty much defined in the Genocide Convention, which we had already signed, but crimes against humanity, war crimes, and so that was useful.